plaintiffs Andrew Griffin, Brittney Jackson, Tony Mathis, Christina O'Donnell, and Nick Hatzievstathia allege various counts of defamation against defendants. Based on the complaint's allegations, each of these plaintiffs is either a public figure or a limited-purpose public figure under Pennsylvania law. It is clear, based upon thorough reading of the complaint and the presentation of counsel at oral argument, that Andrew Griffin or Brittney Jackson, Tony Mathis, Christina O'Donnell, and Nick Hatzievstathia are public figures, limited public figures, as they have injected themselves into the public eye to find the missing child from Tennessee. These plaintiffs have either held press conferences, appeared on the television news, or have engaged in social media discussions or created social media posts related to the missing child. As public figures or limited-purpose public figures, these plaintiffs have a higher burden when raising allegations of defamation due to the inherent right and claims of free speech grounded in the First Amendment. As public figures or limited-purpose public figures, these plaintiffs bear the heightened burden of establishing that the statements made by defendants were false. But plaintiffs have failed to establish this in their complaint. First, this court reiterates that the complaint is devoid of the clarity required by the rules, and, as a result, it is difficult to discern what, if any, statements at issue here can be attributed to either defendant, even if the court were able to ascertain the allegedly violative statements. Statements of opinions that cannot be established as provably false are protected by the First Amendment. Moreover, an expression of an opinion does not give rise to a claim of defamation. As to plaintiffs Griffin and Jackson, only the complaint identifies purported direct quotations of the purported defamatory statements of only defendant grannies watching. Ms. Griffin claims to have been defamed by defendant by the statements tragedy pimp and grifter. Ms. Jackson claims to have been defamed by defendant by statements that she was a lazy, wasteful piece of shit, and that defendant stated, "You won't ever catch me driving with my children unbuckled and standing up." But there is no identification of any specific time when these statements were said or any evidence other than the bald allegations, not verified by plaintiffs Jackson or Griffin, corroborating the suggestion that in these statements were made by defendant. There is also no reference to who heard these purported statements and how these statements were said, or that they caused actionable damage to either plaintiffs Griffin or Jackson. While she makes a vague and general allegation that defendant, calling plaintiff Jackson a lazy, wasteful piece of shit, caused her humiliation, damaged her personal or professional reputation, or affected her professional standing, the complaint does not otherwise describe Ms. Jackson's purported professional reputation. Moreover, there is no allegation that would establish that any of these statements were false, and to the extent they were defendants' subjective opinions, they are not actionable. Plaintiffs Andrew Griffin, Brittney Jackson, Seth Rogers, and Christina O'Donnell's purport to state claims of intentional infliction of emotional distress. To prevail on a cause of action for IED, a plaintiff must establish the following: emotional distress, and for the distress must be severe. A thorough reading of the complaint leads the court to conclude again that plaintiffs have failed to plead with clarity or specificity, and cannot demonstrate that defendants' conduct was outrageous or extreme. Once again, this court notes that the alleged YouTube broadcasts/podcasts have not been quoted or specifically referenced, without the specific statements of defendants vis-a-vis the plaintiffs asserting an IED claim. This court cannot determine that any statement was so atrocious or outside the bounds of civilized society to have caused a harm to plaintiffs. The few quotations of purported statements of defendant that are contained in the complaint, that Ms. Griffin is a tragedy pimp, or a grifter, or that Ms. Jackson was worthless and lazy, do not allow the court to conclude that there is a cognizable IED claim. Further, None of the plaintiffs has pled that actions or statements of defendants have caused them to seek a medical diagnosis or treatment. There are only the threadbare allegations that these plaintiffs suffered emotional pain and mental anguish. As such, plaintiffs have failed to establish a prima facie case to recover for IED, and these claims must be dismissed.